to break, we had a caller, si Bernardo. Ang tanong niya po, pwede ba natin sagutin? His question was, he had a petition, but then there was an issue and there was a case. The child went back to the Philippines. He re-petitioned in 2005. So at what status are we at with this situation?
Well, I think what we're looking at here is whether or not the conditional residency prior and the issues surrounding the cancellation of the conditional residency will have an effect on a future petition. And it's hard to say, but generally speaking, if there is an issue with a conditional residency, a lot of that revolves around marriage fraud. And if there was a finding of marriage fraud in that previous application or that previous condition, that might be an issue. If it's the child, it probably wouldn't directly affect the child since that person is not involved with the principal marriage. So in that way, it might have an effect. It also might have an effect if there's a removal order, if this was done through the court systems and they terminated conditional residency and then he had to go back, then there's a removal order and you have to deal with that when you come back as well. So all of those, there's a lot of issues that may float around the conditional residency. It usually doesn't just disappear into the ether. Something happens.
That's right. And that needs to be addressed.
And that's the main point. Whether it becomes an issue or not is a question mark, but it always will come up and it always needs to be addressed. Even though things were 10 years, 15, 20 years ago, the record is never wiped clean.
Really? Never?
No.
Okay.
It is always something that definitely needs to be disclosed when you're moving forward with the immigration visa application.
Okay.
And like Richard pointed out, it might not cause an application to be denied, but it's something that needs to be addressed, it needs to be answered, and it needs to be at least given the opportunity for the embassy to analyze if it is a problem.
Okay, at kasama naman natin ngayon si Sita. Sita, ano po yung tanong ninyo para sa ating mga abogado dito sa Kababayan Today?
Yes, Ms. Tunji, good afternoon.
Good afternoon po.
Yeah, I just want to ask about the petition of my children because we are here with my husband in America, and my husband were petitioned by her American citizen parents, F3. So we were petitioned October 1996, and the children are already over age. They were petitioned when they were 6 years old, and now the oldest one is 25 years old. So my question is if they can still come here with the petition, even though they are over age.
Yeah, we can hear from Sita's voice that she's really affected by this. That's a long time to wait.
It's a long time to wait, and it's an unfortunate circumstance. There is some help in the Child Status Protection Act that tries to sort of expand the window in which children can follow to join their parents who are petitioned. But you know, if it sounds like that probably didn't happen in their case, the only thing you can do is turn around and petition for them again and go through that process with them. But it's a long process to do. But I would check to see if they were somehow included in under the Child Status Protection Act, that maybe they can come with them now.
Okay, kasama naman natin si Rodolfo. Rodolfo, welcome to Kababayan Today. Ano po yung tanong ninyo?
Hi, G. Good afternoon. Good afternoon, Attorney Aquino and Attorney Loew. My question is this. My cousin petition has 2 kids. Yung anak niya was less than 20 years old when it was approved. Ngayon, nung dumating sa National Visa Center, dinowngrade yung F2A to F2B. My question is, can the NBC unilaterally downgrade the application when it seems that the child was really a minor when he was petitioned by his parents?
Well, actually, that is a good question because what individuals need to understand is that just because a petition starts off in one category, it does not in any way mean that it's going to remain in that category. And a lot of petitions that starts off at F2A do in fact change to the slower F2B category. Now, with regards to his particular question of the NVC and whether they have the authority to do that, they do have the authority because that is their role and their purpose is to determine which category an individual falls in. With that said, we have unfortunately seen the NVC make mistakes all the time. Not all the time, but there are occasions where they will make mistakes. And we have had one particular client who, for example, went through that same situation, was classified F2A, then was reclassified to F2B, and didn't know that the reclassification was wrong, and wasted 5 years before we were able to go in, see that the reclassification was incorrect, and let the NVC know, hey, your analysis was wrong. They really should have been able to stay within that F2A category. So individuals should probably take a look, especially if you start off on the F2A category. The Child Status Protection Act is very difficult, and sometimes it takes us to explain to them what the law is and what the proper analysis is.
Okay. All right. Magbabalik po tayo dito sa Kababayan Today. Wag po kayong aalis, and we'll answer more of your questions. Maraming salamat po.